Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in M-O-A-C Mall Holdings LLC v. Transform Holdco LLC. In this case, the court considered this issue. Does Bankruptcy Code Section 363M limit the jurisdiction of appellate courts over an order approving the sale of a debtor's assets, or instead simply limit the remedies available on appeal from such an order? The case was decided on April 19, 2023. The Supreme Court held that Section 363M of the Bankruptcy Code, which restricts the effects of certain successful appeals of judicially authorized sales or leases of bankruptcy estate property, is not a jurisdictional provision. Justice Ketanji Brown Jackson authored the unanimous opinion of the court. Congressional statutes often contain restrictions and conditions on relief, but absent a clear statement that a provision is jurisdictional, courts must not treat these restrictions and conditions as jurisdictional. Jurisdictional provisions limit the power of the district court, whereas other limitations bear on the rights or obligations of the parties. Nothing in the limiting language of Section 363M purports to govern a court's adjudicatory capacity. First, the text does not address a court's authority or refer to the jurisdiction of district courts. Second, the structure of the code and context of Section 363M suggest it is not jurisdictional. The provision is separate from other provisions in the code that address federal courts' jurisdiction over bankruptcy matters. And unlike other provisions, Section 363M contains no clear tie to the jurisdictional provisions. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Jackson delivered the opinion of the court. Under conditions prescribed by Congress, the Bankruptcy Code permits a debtor or a trustee to sell or lease the bankruptcy estate's property outside the ordinary course of the bankrupt entity's business. 11 U.S.C. Section 363b. Interested parties may file an objection to such a sale or lease, and may appeal if the court authorizes a sale or lease of the estate's property over their objection. However, Section 363M restricts the effect of such an appeal if successful. Specifically, Section 363M states that the reversal or modification on appeal of an authorization under Section 363b or Section 363c of a sale or lease of property does not affect the validity of a sale or lease under such authorization to an entity that purchased or leased such property in good faith, whether or not such entity knew of the pendency of the appeal, unless such authorization and such sale or lease were stayed pending appeal. Accordingly, sometimes, a successful appeal of a judicial authorization to sell or lease estate property will not impugn the validity of a sale or lease made under that authorization. In this case, we are called upon to decide whether Section 363M strictures are jurisdictional. If so, a party may invoke that provision at any time, without fear of waiver, forfeiture, or similar doctrines interposing. If not, courts can apply such doctrines when evaluating Section 363M issues, where appropriate. For the reasons explained below, we conclude that Section 363M is not a jurisdictional provision. This saga began in 2018, when Sears, Roebuck & Company filed for Chapter 11 bankruptcy. That filing created a bankruptcy estate that included interests of the debtor and property. Section 541A(1). Such an estate is sometimes administered by a bankruptcy trustee. Other times the debtor itself administers it as the debtor in possession. Sears self-administered, and as a debtor in possession, Sears had statutorily qualified powers to dispose of the estate's property. Early in 2019, Sears exercised one of those powers, its right to use, sell, or lease, other than in the ordinary course of business, property of the estate. Section 363b(1). Sears agreed to sell most of its assets to respondent Transform Holdco LLC, after which the bankruptcy court issued an sale order, approving the agreement. Among the assets conveyed in that sale was the right for Transform to designate to whom a lease between Sears and some landlord should be assigned. The agreement did not actually designate any assignees. It simply meant that, if Transform duly designated an assignee, Sears had to assign the lease to the designee. One of the leases eligible for such assignment was Sears's lease with petitioner M-O-A-C Mall Holdings LLC, which leases spaces to tenants at the Minnesota Mall of America. Notably, and as relevant here, Section 365 of the Code prohibits assignment of an unexpired lease to anyone without adequate assurance of future performance by the assignee, and further establishes special adequate assurance criteria related to shopping centers, a term the parties agree describes the Mall of America. In that context, adequate assurance includes assurances that 1. The proposed assignee has a similar financial condition and operating performance as the debtor, as of the time the debtor became the lessee under the lease, and 2. The assignment will not disrupt any tenant mix or balance in the shopping center. Later in 2019, Transform designated the Mall of America lease for assignment to its wholly owned subsidiary, and MOAC objected on the ground that Sears had failed to provide the requisite adequate assurance of future performance by Transform. The bankruptcy court disagreed and approved the assignment to Transform, in a decision that, like the lower courts, we will call the assignment order. Here is where Section 363M entered the picture. MOAC feared that, if it appealed the assignment order, Transform might argue that Section 363M's restrictions limited or barred the appeal. Looking to Section 363M safe harbor for certain orders that are stayed pending appeal, MOAC sought to forestall any such argument by asking for a stay of the assignment order. The bankruptcy court denied MOAC's request for a stay. The court reasoned that an appeal of the assignment order did not qualify as an appeal of an authorization described in Section 363M, and it emphasized that Transform had explicitly represented that it would not invoke Section 363M against MOAC's appeal. Because no stay was granted, the assignment order became effective, and Sears duly assigned the lease to Transform. MOAC then appealed the assignment order to the district court, which initially sided with MOAC and concluded that Transform did not satisfy the pertinent Section 365 adequate assurance provisions. It thus vacated the assignment order to the extent it approved Sears's assignment of the lease to Transform. Transform sought rehearing and, notably, backed away from its previous disclaimers, arguing for the first time that Section 363M deprived the District Court of jurisdiction to grant MOAC's requested relief. The District Court was appalled by Transform's gambit of waiting to invoke Section 363M until after losing the merits of the appeal, but determined that Second Circuit precedent bound it to treat Section 363M as jurisdictional, and thus not subject to waiver or judicial estoppel. The District Court held that Section 363M was applicable, and required it to dismiss the appeal, so it did so, leaving the assignment order unscathed. The Second Circuit affirmed, agreeing with the District Court's characterization of Section 363M as jurisdictional, based on Second Circuit precedent. We granted MOAC's petition for certiorari to resolve the circuit split that the Second Circuit's ruling reinforced. Before this court, Transform not only defends the Second Circuit's characterization of Section 363M as jurisdictional, but also urges us to dismiss this case on mootness grounds, because the lease has already been transferred out of the estate via the assignment. We first address Transform's mootness claim. A case becomes moot only when it is impossible for a court to grant any effectual relief whatever to the prevailing party. The case remains live as long as the parties have a concrete interest, however small, in the outcome of a litigation. Stripped of its baubles, Transform's mootness argument is that MOAC's ultimate relief hinges on the bankruptcy court's ability to reconstitute the leasehold as property of the estate. Transform asserts that such reconstitution is impossible unless the leasehold transfer is avoided under 11 U.S.C. Section 549, which permits a debtor in possession to void certain transfers of estate property made after the bankruptcy case commences. But, according to Transform, only Sears can use Section 549. And, per Transform, not only did Sears waive any such avoidance claims in the sale order, but the time for using Section 549 has now expired. The upshot for Transform's mootness argument is that no legal vehicle remains available for undoing the lease transfer, and therefore MOAC cannot possibly obtain any effectual relief, irrespective of our answer to the question presented. Our cases disfavor these kinds of mootness arguments. In Chafin, for example, a mother invoking the Hague Convention on the civil aspects of international child abduction sought, and received, an order from a federal district court that her child be returned to Scotland from the United States, where the child was residing with her father. The father appealed, seeking reversal and a concomitant re-return order, but in the interim the mother had removed the child to Scotland, so the appellate court dismissed the father's appeal as moot. Before us, the mother defended the mootness holding on the grounds that the district court on remand would lack the authority to issue a re-return order either under the convention or pursuant to its inherent equitable powers. We disagreed? We said her argument went to the meaning of the convention and the legal availability of a certain kind of relief, and thus confused mootness with the merits. And, at least where the father's contrary re-return argument was not so implausible that it was insufficient to preserve jurisdiction, his prospects of success were therefore not pertinent to the mootness inquiry. So too here, like the father in Chafin, MOAC simply seeks typical appellate relief. That may be effectuated by ordering a transfer of funds or property from one party to another, and just as in Chafin, Transform's theory for mootness depends on the meaning of a statutory provision, namely, Section 549. But that merits question should be decided in the first instance by the courts below, not us. And where MOAC's argument that reconstitution is legally permissible is not so implausible as to defy reality, we will not declare this case moot. To the contrary, MOAC has advanced a plausible argument that, were it to prevail on appeal, the bankruptcy court could fashion relief under Section 105A of the Code, which vests courts with statutory authority to issue any order, process, or judgment that is necessary or appropriate to carry out the provisions of this title. Of course, Transform vigorously disputes that argument. But we cannot declare MOAC's appeal moot when we have no idea whether the bankruptcy court could take action to restore some or all of the transferred leasehold. Were MOAC to prevail, Transform has identified no insurmountable obstacle to that approach, and so we think MOAC retains an interest in the outcome of the case sufficient to preclude a finding of mootness. The case is not moot. Turning to the merits, we conclude that Section 363M is not jurisdictional. In reaching that determination, we adhere to our established framework for evaluating whether a statutory provision is jurisdictional. Under that framework, we begin with the text and context of the provision at issue, which are dispositive where Congress provides a clear statement that a provision is jurisdictional. Where that is lacking, we look to other contextual cues, but only to the extent that they clearly state that the provision is jurisdictional. And we heed our usual guardrails against profligate use of the term jurisdictional in the interpretation of statutes. Starting with the text, Section 363M provides, in full, the reversal or modification on appeal of an authorization under subsection B or C of this section of a sale or lease of property does not affect the validity of a sale or lease under such authorization to an entity that purchased or leased such property in good faith, whether or not such entity knew of the pendency of the appeal, unless such authorization and such sale or lease were stayed pending appeal. By its terms, this provision stops certain transactions authorized by the bankruptcy court from being undone on appeal. That promise protects the finality of those sales or leases, which in turn encourages good faith third-party purchasers to invest in the bankruptcy estate. Thus, we have said, finality is important in bankruptcy because it orders the priorities and rights of various creditors and parties in interest in such a way that those parties can plan accordingly. But Section 363M says nothing about whether the absence of a stay strips the reviewing court of jurisdiction, nor does it address whether a reviewing court must dismiss an appeal in that situation, as Transform has urged at every stage of this litigation. Instead, Section 363M prevents the reversal or modification of a sale authorization order, without specifying that doing so would affect the reviewing court's jurisdiction over the underlying dispute. Thus, the most natural reading of the text is that Section 363M is a statutory limitation, rather than a jurisdictional one. The surrounding context confirms this conclusion. Congress has enacted other provisions in the Code that expressly refer to limits on a court's jurisdiction. For instance, Section 524E permits a court to enjoin or restrain certain activities, as long as doing so does not affect the liability of any other entity on or regarding the debtor's discharged debt. However, Section 524G qualifies that general rule by permitting a court to issue such injunctions against certain third parties if the injunction complies with specific requirements. Yet, even where those requirements are met, the district court still may not have jurisdiction over a suit challenging an injunction unless specified conditions are satisfied. Or take the Code's catch-all venue provision, which says that a district court may not hear bankruptcy cases if the district court determines that venue will be inconsistent with the prescribed requirements, unless the parties to the proceeding agree otherwise. Or the provision saying that, in cases under certain code chapters, a court may not confirm a plan that seeks to modify the claim of a creditor unless that creditor has accepted the plan. The absence of such language in Section 363M is telling. This contextual point is fortified by our usual presumption that Congress does not hide elephants in mouse holes. We expect Congress to speak clearly when it intends to impose conditions on jurisdictional grounds, and, in light of the above context, Congress's failure to use language similar to Sections 524G, 1409D, or 1129B, 2AI2 speaks volumes. Other contextual clues reinforce our view that Section 363M is not jurisdictional. As we have noted, statutory provisions that contain preconditions to relief or elements of a plaintiff's claim for relief are usually non-jurisdictional. For instance, in Henderson v. Shinseki, we evaluated a statutory deadline for taking an appeal to the Veterans Court, which said the appellant shall file a notice of appeal within 120 days. We held that provision to be non-jurisdictional because it merely provides a deadline for seeking relief, rather than conditioning the exercise of the Veterans Court's jurisdiction on timely filing. Similarly, in Bochler, we held that a statutory deadline in the Internal Revenue Code was non-jurisdictional. There, Congress said that the appellant may appeal an adverse determination to the tax court if the appeal was filed within 30 days. That provision lacked a clear jurisdictional statement, and, although it was framed as a condition, it did not speak in jurisdictional terms or refer in any way to the jurisdiction of the tax court. Instead, the provision simply described a precondition to relief by specifying what a prospective appellant must do before obtaining relief. The same is true here. Like the statutory deadlines in Henderson and Bochler, Section 363M mandates the procedures that a party must follow to obtain an orderly remedy. Specifically, Section 363M speaks only to whether courts can affect the validity of a sale or lease under the prescribed conditions. It does not speak in jurisdictional terms or refer in any way to the jurisdiction of the reviewing court. In this way, Section 363M merely limits the relief that courts can order. It does not delimit the adjudicatory authority of the courts. This conclusion is further confirmed by the traditional distinction between claims processing rules and jurisdictional rules. Jurisdictional rules govern a court's adjudicatory authority by delineating the classes of cases a court may entertain, whereas claims processing rules simply seek to promote the orderly progress of litigation by requiring that the parties take certain procedural steps at certain specified times. Section 363M is a claims processing rule. It does not delineate the classes of cases that the courts can adjudicate, but rather prescribes certain steps that the parties must take to have their claims proceed in an orderly fashion. Accordingly, Section 363M is not jurisdictional. Finally, we address Transform's alternative theory for why MOAC's appeal should have been dismissed, namely, that Section 363M independently renders this case moot. The short answer is that Transform's reading of Section 363M is contrary to our precedents, which explain that this provision does not strip courts of jurisdiction, but merely strips appellate courts of the power to provide certain remedies. And as the Second Circuit correctly held, that view aligns with the natural meaning of Section 363M's text. By its terms, that provision stops certain authorized sales from being undone on appeal, but it does not preclude all relief in any manner extending beyond that function. Simply put, mootness and the scope of relief are two distinct doctrines, and Section 363M speaks to the latter, not the former. For the foregoing reasons, we vacate the judgment of the Court of Appeals, and remand the case for further proceedings consistent with this opinion. It is so ordered. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.